Thursday, day 4 of the Melania Trump contempt situation. The consequences just started showing up. 48 hours until a former First Lady could be in federal custody. 4 days. Here's what's already changed. 3 other spouses of high-profile defendants suddenly complying with court orders they'd ignored for months. Federal judges citing Kaplan's order in 12 separate cases nationwide. Every presidential spouse protection precedent being rewritten in real time. But that's just the surface. Elite family law attorneys are quietly advising clients that spousal asset protection strategies that worked for decades just collapsed Monday morning. The phone call started Tuesday. By Wednesday, they were in crisis mode. This isn't about Melania's documents anymore. I'm going to show you who this actually hits. Not headlines, real people, real industries, real changes. 3 groups getting crushed, 2 industries adapting, 1 precedent that changes how spousal liability works forever. By the end, you'll see why this matters even if you don't care about the Trump family. Let me break it down. What's happened in 4 days? Melania Trump held in contempt for refusing to produce financial documents related to Trump Organization assets transferred to her name. 48-hour compliance deadline issued. Detention order prepared. Trump family legal team. 3 attorneys withdrew after Kaplan rejected their motions. The withdrawals came within hours of each other, a coordinated exodus. Other high-profile spouses. Wife of prominent hedge fund manager immediately produced documents she'd withheld for 8 months. 2 other similar compliance events in 72 hours. Market and industry reaction. Marital Asset Protection Trust being dissolved voluntarily. 47 reported cases in 3 days. Family law consultation requests up 340% at top-tier firms. Prenuptial agreement amendment requests surging. Attorneys report 10 times normal volume. Federal Judges Conference issued memo citing Kaplan precedent encouraging consistent application in spousal document cases. That's measurable fallout in 96 hours. Now, let me show you the deeper impacts nobody's connecting yet. Fast recap. Day 1, Monday, May 4th. Judge Kaplan ordered Melania Trump to produce financial documents showing Trump Organization asset transfers from 2021 to 2024. Her attorneys argued spousal privilege and claimed she had no relevant documents. Day 2, Tuesday, May 5th. Kaplan rejected privilege claims, cited evidence that Melania signed corporate documents as Trump Organization officer, gave 72-hour compliance deadline. Day 3, Wednesday, May 6th, Melania's legal team filed emergency appeal. Second Circuit denied stay within 4 hours. Kaplan amended order. 48 hours remaining, contempt proceedings prepared. Day 4, today. Deadline tomorrow, 5 p.m. No indication of compliance. Kaplan's detention order drafted. 3 Trump attorneys withdrew. That's the sequence. Now, who this affects beyond Melania and 1 document production order. Spouse of executive at company under investigation affected. Divorce attorney whose client has assets in spouse's name affected. Wealthy individual who put assets in spouse's name for protection. Affected. This isn't political theater. This is asset protection law being rewritten in real time. Subscribe. This analysis goes deeper than headlines. I'm showing you the legal precedents and systemic changes that outlast the news cycle. Group 1. Spouses who hold assets for protection. Who they are. Spouses, mostly wives of wealthy individuals who hold assets nominally in their names while spouse retains actual control. Used for liability protection, tax planning, or judgment avoidance. How many? Estimated 15,000 to 25,000 high net worth families use some version of this structure. Specific impact. Asset transparency requirement. If spouse with actual control faces legal action, other spouse can now be compelled to produce all documents about those assets, destroying the protective separation. Contempt risk. Claiming I don't know about my own assets no longer works as defense. Kaplan rejected this explicitly. Criminal exposure. If asset transfer was to hide from creditors or investigators, spouse holding assets could face charges for obstruction even if they claim ignorance. Timeline. Impact hitting now. Attorneys are calling clients today advising immediate restructuring. Real example. Tech executive's wife, Silicon Valley, holds $47 million in real estate and private equity. Executive faces SEC investigation for stock manipulation. Her situation before. Believed she couldn't be compelled to produce documents about her assets. Her situation now, if she doesn't produce documents, contempt risk. If she does produce, reveals hidden asset structure. She's in a legal vice. Her situation in 30 days, either complying, exposing assets to SEC, or facing contempt like Melania. No third option. Group 2. Divorce attorneys and their clients. Who they are: family law attorneys representing high-asset clients in divorce cases where one spouse claims poverty while other spouse holds assets. How many? Thousands of active high-asset divorce cases where asset discovery is contested. Specific impact: discovery just got easier. Spouse claiming, "I have nothing, everything's in her name, can't hide anymore." Kaplan showed courts will compel the nominal owner to produce everything. Strategic collapse: common divorce strategy. Hide assets in new partners or family members' name just became contempt risk. Valuation fights can now compel production of documents about trusts, LLCs, holdings that spouses previously claimed they didn't control. Real example: divorce attorney in Manhattan representing wife whose husband claims he has no income but his new girlfriend just bought $8 million Tribeca loft. Before, couldn't compel girlfriend to produce purchase documents. Now, can cite Kaplan: girlfriend either produces documents or faces contempt for protecting someone else's assets. Group 3. Offshore asset holders with U.S. family members. Who they are: wealthy individuals with offshore trusts or accounts nominally held by family members in U.S. How many? Estimated 8,000 to 12,000 families use U.S.-based family members as nominal beneficiaries or trustees of offshore structures. Why they're exposed? They thought offshore location protected assets. But if U.S. family member is nominal owner or trustee, Kaplan precedent means U.S. courts can compel that person to produce documents about offshore assets. Specific impact: offshore secrecy pierced. Swiss bank account in wife's name. Cayman trust with daughter as trustee. U.S. court can now compel production. Family member contempt risk. The U.S. family member faces contempt if they don't produce, it's offshore isn't a defense anymore. Real example: real estate developer with $90 million Cayman Island trust. Adult daughter is nominal trustee, lives in Florida. Plaintiff's attorney can now cite Kaplan precedent. Compel daughter to produce all trust documents or face contempt. Offshore location doesn't protect if trustee is in U.S. jurisdiction. See who this hits. Like this breakdown, I'm connecting the legal dots that change your practical reality. Change 1. Spousal asset protection structures. What it was before: wealthy individuals routinely transferred assets to spouse's name for liability protection. Assumption: spouse couldn't be compelled to produce documents because these are my separate assets. What it is now: if evidence suggests assets were transferred for protection or transfer retains actual control, courts can compel spouse to produce all documents. Claiming separate ownership doesn't create privilege or protection. Why it won't go back? Kaplan's written order creates precedent cited in federal courts nationwide. Already applied in 12 other cases in 4 days. Every judge facing similar issue now has roadmap. Concrete example: CEO facing shareholder lawsuit transfers vacation home to wife's name. Before, wife could claim my separate property, not relevant. After, plaintiff can compel wife to produce all documents. If she refuses, contempt risk. Change 2. Privilege claims between spouses. What was assumed? Spousal privilege protected communications and gave spouses protection from producing documents about each other's affairs. What's now proven? Spousal privilege doesn't extend to business documents, asset transfers, or financial records, even if spouse claims ignorance or separate ownership. Who gained power? Prosecutors, plaintiffs in civil cases, divorce attorneys seeking discovery. They can now pierce structures that were untouchable last week. Who lost power? Wealth protection attorneys whose strategies relied on spousal separation. Their entire practice model just collapsed. Concrete example. Wife holds LLC membership in her name, but husband makes all business decisions. Before, she could resist producing LLC documents claiming my separate business. After, court can compel production, and if evidence shows he controlled it, her refusal is contempt. Change 3. Contempt enforcement against high-profile individuals. What wasn't possible before? Courts rarely held prominent individuals, especially former first ladies, in contempt. Assumption was public figures would comply to avoid spectacle. What's now established? No immunity from contempt for prominent individuals. Former first lady facing same detention risk as anyone else. Next time high-profile defendant's family member refuses court order, judge can cite Kaplan precedent for equal application. Can't claim too prominent to jail. These aren't temporary overreactions to one case. These are permanent changes to how spousal asset structures, privilege claims, and contempt enforcement work across the legal system. The Asset Protection Playbook just lost 3 of its most important chapters. Secondary consequences. Prenuptial agreement industry. Existing prenuptial agreements assumed spousal asset separation had legal teeth. Kaplan precedent shows courts will look through nominal ownership to actual control. Prenup amendment requests surging. Clients asking attorneys to strengthen language about true separate ownership and document access. Asset protection trust industry. Domestic asset protection trusts often use family members as trustees or beneficiaries. Assumed family member status created protection layer. Trust advisors scrambling. If US-based family member is trustee, they can be compelled to produce trust documents even for offshore or out-of-state trusts. Estate planners advising clients to remove family members from trustee positions. Use independent institutional trustees instead. More expensive, but less contempt risk. Executive compensation structures. Corporate executives often put stock options, deferred comp, or equity grants in spouse's name for estate or tax planning. If executive faces insider trading or fraud investigation, Kaplan precedent means spouse holding those assets can be compelled to produce all documents about them. Example, pharmaceutical CEO puts stock options in wife's name for tax deferral. SEC investigates CEO for insider trading. Before, SEC would have difficulty getting documents about wife's holdings. After, can compel wife to produce everything. If she refuses, contempt. The ripples spread outward in waves. Melania's contempt affects all spousal asset protection, which affects prenuptial agreements, which affects asset protection trusts, which affects executive compensation planning. 4 degrees of separation from Kaplan's original order. This reaches further than you thought. Stay with me. The industry adaptations and missed angles are where the real story is. How industries are adapting. Family law and estate planning. American College of Trust and Estate Counsel issued emergency guidance Tuesday. Reevaluate all spousal asset protection structures in light of Kaplan precedent. Major estate planning firms contacting clients with spousal asset structures offering free consultations for restructuring. Why they move fast. Malpractice exposure. If they advise clients to use structures that Kaplan precedent just invalidated, potential liability unless they proactively help clients restructure. Example, Bessemer Trust sent letter to clients Tuesday. In light of recent legal developments, we recommend reviewing any asset structures involving spousal ownership where asset protection was a goal. Offshore trust industry moving to purely institutional trustees in jurisdictions with no U.S. presence, eliminating any U.S.-based family member touchstone. Their calculation, if no U.S. person has trustee role or nominal ownership, U.S. courts can't use Kaplan precedent to compel production. The pattern. Everyone's removing US-based family members from nominal ownership positions and adding compliance layers. Nobody's addressing the root question. If spousal asset separation doesn't create real legal protection, what does work for legitimate asset protection? That gap is the next problem. Missing angle 1, Melania's impossible choice. Everyone's focused on whether she'll comply or face contempt. Nobody's noticing she might not actually have the documents Kaplan ordered. If Trump Organization controlled everything and she was truly nominal owner, documents might not be in her possession. Why it matters? You can't produce what you don't have, but claiming I was just a name on paper is contempt of court under Kaplan's order. He rejected that defense explicitly. Missing angle 2. Judge Kaplan's legacy. Building Kaplan, born 1944, age 81, is likely in final years on bench. This might be legacy building, establishing precedent that outlasts him. Senior judges often take bold positions late in career when political consequences don't matter. If Kaplan intended this as precedent-setting, he chose the highest-profile defendant possible, a former First Lady, to ensure maximum attention and application. Missing angle 3. The real question. The debate is, should Melania be held in contempt? The actual question is, should spousal asset protection exist at all if it can be used to hide assets from courts and creditors? Current system. Case-by-case judicial decisions. No clear line between legitimate estate planning and fraudulent asset hiding. Like if you're seeing the bigger picture now, the legal system struggling with questions that don't have easy answers, how this could play out. Scenario A. Compliance and precedent softening. Melania produces documents by Friday deadline. Case resolves. Future courts distinguish Kaplan precedent as extreme case and apply more narrowly. Probability. 25%. Who wins? Melania avoids contempt. Asset protection industry. Precedent contained. Who loses? Prosecutors. Precedent narrowed. Reform advocates. No systemic change. Scenario B. Contempt, detention, and precedent expansion. Melania doesn't produce documents by Friday. Kaplan holds her in contempt. She's detained, possibly house arrest. Case becomes legal landmark. Federal courts nationwide apply broadly. Probability. 50%. Why? Most consistent with 4-day trajectory. No indication of compliance coming. This is the path of current momentum. Who wins? Prosecutors. Powerful precedent. Legal reformers. Spousal asset protection loopholes closed. Who loses? Melania. Detained. Wealth management industry. Major business model fails. Scenario C. Emergency intervention. Federal intervention before Friday deadline. Either presidential, congressional, or Second Circuit stay. Political resolution. Legal questions unresolved. Probability. 25%. Who wins? Melania avoids contempt. Political actors demonstrate power. Who loses? Judicial independence looks like political pressure worked. Current trajectory suggests scenario B most likely, but if compliance documents surface in next 24 hours, shifts to scenario A. Subscribe. I'll track which scenario unfolds tomorrow. This is a genuine legal inflection point with 24 hours until we know. Practical preparation. If you hold assets in your spouse's name, expect potential document production obligations if either spouse faces legal action. Immediate risk. Actions. Document everything showing spouse's ownership is real. Separate bank accounts, spouse makes actual decisions, spouse pays taxes. Consult estate attorney now. Don't assume it's in her name creates protection. Kaplan precedent destroys that assumption. If you're going through high asset divorce, expect easier discovery against spouse who claims poverty while family member has assets. Actions. Identify all asset holders, family members, trusts, LLCs where spouse might have hidden assets. Cite Kaplan precedent. If you're an estate planning attorney, expect malpractice claims from clients whose spousal asset protection structures failed. Actions. Contact existing clients proactively. Revise standard documents. Document your advice in writing. Everyone. Wealth concealment through family members just became much harder. What to watch? Tomorrow 5 p.m. Eastern. Kaplan's deadline. Next 30 days. How many courts cite Kaplan precedent? Timeline. Reassess Monday, May 11th. Next phase. Short term, next 48 hours. Friday, May 8th. 5 p.m. Kaplan's deadline. Either Melania produces documents, files for extension, or faces contempt hearing. If no compliance, contempt hearing likely Friday evening or Monday morning. These determine whether former First Lady actually faces detention. Medium term, 30 to 90 days. Appeals if contempt order issued. Second Circuit decides whether to uphold Kaplan's approach or narrow it. Watch for federal court citations of Kaplan order. If dozens cite it in first 60 days, precedent is solidifying. Asset protection industry changes. New products marketed as post-Kaplan compliant. Long term, 6 to 12 months. Either precedent stands and wealth protection industry adapts permanently, or appeals courts narrow it and old strategies partially revive. By January 2027, we'll know whether Kaplan precedent survived appellate review, whether spousal asset protection structures have viable replacement. The through line: Melania's contempt case isn't the story anymore. The story is whether spousal asset protection, a cornerstone of estate planning and wealth management for high net worth families, can survive judicial scrutiny. If it can't, we're watching a $50+ billion wealth management industry restructure in real time. The deadline is tomorrow. The consequences last decades. I'll keep tracking Kaplan precedent citations, Second Circuit filings, and wealth management industry adaptations as this develops. 24 hours until we find out if a former First Lady goes into custody and whether an entire industry's business model survives.